Good evening, everybody. It's John here from Tutor Tube, welcoming you along to our live stream. And tonight we've got a Paper 1 clinic. So we are thinking about your OCR A-Level Law and particularly about Paper 1. I know we're a few days away from the exam. I'm joined tonight by Laura. Good evening, Laura.
Hello.
So what we're going to do is we're going to try and field as many questions as we possibly can, Laura, aren't we? So what I would like is, if you are joining us live, please do start putting some questions into the YouTube chat window now, and Laura will do her very best to answer as many of those questions as we possibly can. We've got about 30 minutes or so let's see how many questions we can get through. We've also got a little bit of a PowerPoint ready if we need to talk about some of the structures of the exam and so forth, but we'll try and concentrate on questions to begin with. Laura, just as we're waiting for one or two questions to come in, if you were to give us 2 or 3 tips relating to Paper 1 in particular, what would be the first things that come into your mind?
My first thing would be that when you open that paper, you need to plan your questions. I say it so much to my students that don't just get cracking on a question, literally work out what the answers want in, break it down and put a plan there, tick it off as you're going through, and then you'll make sure you get as many marks as you possibly can. It doesn't matter which side you do. You can choose whichever sides if you want to do part A or part B first. Play to your strengths. If you know something really well, get it out of the way first, and write it and get it down, and then move on to the other things that are there as well. Oh, I think we've got a question,
like really good
John.
Advice. I think we have got a question from X. Shall we can try and get that up on screen? I'll hand over to you.
Brilliant. Fabulous. So it says, can a question on actus reus alone come up? It came up alone a few years ago. So when the mens rea question came up a few years ago, I suppose most teachers were quite shocked that it actually came up there. So I would say yes, actus reus could come up on its own. You could be looking at a 20 mark emissions question, and it could ask you just to talk about emissions. If that came up, you probably would have one or two issues in there. So maybe a duty under contract, maybe a duty of like a public officer or somebody doing a public duty, and then you would have to talk about those. Causation could come up on its own 20 marker as well, so you could definitely have that. I would also say strict liability, that could come up as a 20 marker, so X definitely. I would be advising my students right now to make sure they're prepared for all of these eventualities. Everything you've been taught on that course could, in theory, come up either as part of a question or as a 20 marker. So yeah, definitely, I would be revising the elements of actus ratio, emissions and causation as well. Perfect. So if we go with Tanvi, brilliant, thank you. So for the legal system, do we need to evaluate, and how many evaluations do we need to do? So legal system comes up on section A, so that is your first part. You will have 2 questions, which are 8 markers, knowledge, you get to choose between, and then you have 2 12 markers. The 2 12 markers are evaluation points, and what you want to be doing there is you want to be making ideally 3 or 4 what we call well-developed points. So that's where you make a point, a statement of evaluation. You then do a developed point, which you evaluate that, so you explain why that's a point of evaluation. And then you've got a well-developed point, so that's where you can either bring evidence or casing, a casing that backs up what you're saying, or a counter argument. Counter arguments you can get marked for, but you need to make sure that you actually really address that evaluation point first as well. So in terms of the legal system, you could get ones asking about the evaluation of juries, so advantages and disadvantages. There is the judges question. So last year there was the independence judges question, but you could also get a generic evaluation on judges as well. And then there is the civil courts as well, so you could get the civil courts and ADR. So you could, like last year, be asked to evaluate one of them, like mediation, or you could be asked to evaluate like the benefits of using ADR over civil courts, or vice versa. That could be a question as well. So yeah, you would need to do it, and you want to be aiming between like 3 and 4 well-developed points on there. So making a little paragraphs, 3 or 4 little paragraphs on evaluation. You do not need to conclude though, and you don't need to do an introduction on those 12 markers. So on section A, you just go straight into those evaluation points and try and make 4 of those well-developed points. I hope that answers your question. Brilliant. If you mess up on evaluation, can you still do well? Are we meaning the 12 marker on this one? If you do the 12 markers, yeah, of course, absolutely, you could still do absolutely well. If we're talking about the substantive law element, so the criminal law, there is an evaluation question on the section B side, which is your criminal law. That'll be the same evaluation question on both sides of section B. And for that, if you mess up the evaluation part, it's nothing necessarily to worry about, because remember, it's out of 20 marks. So you have 8 marks for your AO1, which is your knowledge. So you can still be gaining 8 marks there, because you will be preparing your AO1 if it would come up as a scenario, because remember, these evaluation questions, you've got intoxication, that could be a scenario, consent, self-defense, the non-fatal offences, all of those could be scenarios too. So you've still got that 8 mark AO1 element, exactly the same as if it was a scenario. And then you have got the 12 marks for evaluation. Same principles, you want to make 3 or 4 well-developed points, but if you mess up on that, you've got your 8 marks, so you're 20 mark out of the 20 on AO1 that you can fall back on as well. So it's not necessarily a major thing. I mean, try and make some evaluation points on there, but you have got those 8 marks to fall back on as well in those 20 markers. Brilliant. If we got to the question from X again, so what changes in requirement in the specification for the English legal system this year? I hear you don't need to know the training of legal personnel now. Yeah, that's correct, you don't. So you don't need to know about the qualification process of solicitors and barristers anymore. The questions that could come up there is you could have a role question, so it could ask you to talk about the role of solicitors, the role of barristers, the role of legal execs, the role of judges as well. That's a popular question. So you can look at the judges in terms of like their roles in civil courts, in criminal courts. So you'd look at what they do in each of the courts. It has come up previously for a role question about it's specifically like what the judges do in like the High Court in the division, the different 3 divisions of the High Court, and their role within there as well. But training is definitely not on anymore, so you don't need to know the training its role. You can also be asked about the organisation, so how solicitors and barristers are organised. So like the solicitors, you have obviously got the Law Society, barristers is the Bar Council, so you can be asked how they are organised, but no training and qualification questions anymore. Brilliant. Will, can you just put cases in brackets, as I just want to plug them after I explain the law. So obviously cases, you don't need facts, first thing, and it's the point of law that we're really looking at as part of a case. So if we take, for instance, let's say, let's think of a case. If we go with Gibbons and Proctor from murder. So Gibbons and Proctor tell us that there must be an unlawful killing. That could be the Defendant's Act or an omission. If you wanted to explain an unlawful killing is where the defendant's got an unlawful killing because of the actions or their omission, as seen in Gibbons and Proctor, you can do. So yeah, you can put the case at the end. The point of law is really important. You will then have to attribute that to the case. So you could do it at the start. You could say Gibbons and Proctor states that an unlawful killing is through the Defendant's Act or omission, or you could put it at the end, or you can put it that would be fine. But we're looking for that attribution, that you know the legal point that comes from that case. So definitely that would be on that one. So Tanvir, do we mention AO1 and AO2 together? Also, we mentioned cases as part of the topic. Do we need to relate to the scenario? That's a really good question. So 20-mark questions are scenario questions, and they will be relating to the scenario on the page. What you will have to do is there's 2 approaches to this. You can either talk about all of your AO1 first, which is your knowledge. So it's your definitions and your cases. So you want to outline the stages. If we're thinking, like I've just been talking about murder, you want to outline all the different stages of murder, and you give your cases there as explanations with the legal principles. And then you would do your AO2 afterwards. AO2 is the application, and you would absolutely need to refer to the scenario on that one. So make sure that you put the scenario and talk about it. You could integrate it, and some people do, so they do more of an idea structure where they define an element, put an example, and then application. Cases that are not relevant to the scenario, I would really try and stick to the things that are relevant. Law, especially criminal law, is massive. So if we think about theft, for instance, theft is absolutely huge. If, let's say, your scenario doesn't involve section 5.3 and the idea of davage and bunnet, and the fact that if you're an obligation to deal with property in a specific way, if that's not in the scenario, don't include it. Stick to the things that are specifically in the scenario. Same with like causation. If like it comes up under gross negligence or unlawful act or murder, and there are no intervening acts, or a really clear one like it's medical treatment or medical mistreatment, don't talk about everything. Just stick to what's specifically in that scenario. So definitely, I would make sure your cases that you are using relate to that. Do I think there are any more areas that are likely to come up? Oh, do you know how many times my students have asked me this question over the last couple of weeks? And it's not something I'm willing to say anything could come up. And I think students at this point definitely need to be preparing for absolutely anything. It is hard to second guess and question the exam board. A couple of years ago, diminished responsibility came up, and it could have been easy for a teacher to say, it came up last year, it's not going to come up this year, but then it came up like 2 or 3 years in a row. So that could happen. Something that was on last year's paper could come up again. I really wouldn't edge a bet of guessing what is actually going to come up, because you don't want to box yourself, and you don't want to put yourself at a disadvantage if you've not revised something that's not come up. So my advice would be revise everything that you can do and prepare for everything that you can do as well. Brilliant. Right, fabulous. So we've had a few questions come in. Do I need to answer all the questions on the paper? And the answer is no. This is something really important. You have got choices of what to actually answer on the paper. So there is section A, which is worth at 25% and 20 marks overall. And I always say section A is just as important as section B. So many people think that you can leave section A out or leave it last because it's got the smaller mark questions, but actually it's really important, and it can be the difference between grades. It can really help if there is a harder element on the crime element. So there's 25% of your marks and it's 20 marks. You have a choice of 2 8-mark questions. You choose one of them, don't write both of them. And you have a choice of 2 12-mark questions. Again, you just choose one of them. Then on section B, there are 2 sides to section B. This is your criminal law element. What you need to do is you need to choose one of the sides and answer all 3 questions on that side. Do not start picking between the 2 sides of the paper. That's not how it works. You need to answer just everything on one side and then everything on this, just on one side, the 3 questions, then ignore the ones on the other side. Choose the ones that play to your strengths. So I always say in this one, don't bother reading through the scenarios first. Go straight to your exam questions. Look at the topics that are on there and figure out which ones are your strengths, and then answer that side. Plan it out and then answer it. Remember, on that section B, the same evaluation question is going to come up on both sides. So it's two application scenarios or questions, and then one evaluation question that will be the same on both sides. Brilliant. Have we got another question from the chat? So if we get a question on attempted robbery, for example, do we talk about attempts or robbery as a whole? Excellent question. So this came up a couple of years ago where it was an attempted theft, and so many students made the mistake of talking about theft. If your question says discuss the criminal liability for the attempted offences or attempted theft, then you would talk about attempts. So you would go through your Criminal Attempts Act, Section 1. You would talk about the actus reus, the idea that you're going beyond mere preparation and you're embarking on the crime proper with the examples. You would then talk about your mens rea elements, so the fact that you have to intend the full crime, recklessness is not enough, cases as well. Chances are, and this is a little top tip, if attempts does come up, there probably will be an attempt in the impossible in the scenario. So make sure you learn that section 2.1 as well, and look out for that. Same with attempts, you could potentially have 2 or 3 victims or 2 or 3 defendants in there, so you would have to talk about them separately. So when you get a situation where there's more than one person in the scenario, make sure you go through all of the law of attempts for that person first, then move on to your second issue. Don't swap and change between, try and keep them all together, and then that way you're not going to miss any elements and you're not going to miss any marks either. But brilliant question. If attempts does come up, focus on the attempts. Do not talk about robbery, because there won't be any marks for robbery. Is it possible that both Part 1 and Part B could be criminal liabilities? Example, actus reus in Part 1 and actus reus in causation in Part 2. I think, Shanice, what we're saying here is, are we talking about them being one side of criminal law paper on the section B, and the question 1 being actus reus, question 2 being causation? In theory, yes, that's possible. That could do. It is giving you a very niche section of the question for it to come up, but yeah, in theory, it could do. Same as it could be that you have, omissions on the first side of section B, and then on the second side, so your other option on section B could have causation, and you might have to choose between them. Absolutely possible, and I wouldn't put anything past on this one. I would definitely say it could come up like that. Yeah, it would be niche, but everything's a possibility, definitely. Can we have an evaluation pre-planned for a 20 marker? Yeah. So what I would advise is students to learn their evaluation points. I know that a lot of the criminal law has got specific things that you could talk about. So if we're talking about, let's say, intoxication, you could learn your points on intoxication. You would write about them. But one thing to really, really make sure is, if you are learning these as pre-planned points of what you want to say, you have to link to the question. So if the question's asking you to do something specific, such as, is the law of intoxication in need of reform, you could talk about the fact that there is a loophole, the fact that there is not every specific intent crime has got a basic intent alternative, and you could go in knowing that evaluation point, but what you would have to do is then you'd have to relate it to what it says in the question. So the fact that there is not every offence has a fallback position, that would definitely mean that the law is in need of reform. So I would definitely say that, yeah, you can do it, but you really have to be clear that you would link that to the question, and you would then have to talk about your conclusion as well. So you'd really have to make sure you answer the question, but definitely have an idea of what you want to do. If you forget a case, but remember that the point of law Is that okay? Yeah, definitely. The law is really important, and you would probably still get credit for it as well. You do need case law in your answer, definitely. But if you can remember that point of law, get it in. There is a good chance you're going to get a mark for that one. Absolutely. Fantastic questions coming through. For the non-fatals, if we talk about the wrong offence, do we lose marks? Depends. So if, let's say, you've talked about assault and it's GBH, yeah, you probably will lose marks on that one. Sometimes they can, I mean, if you're trying to decide between section 18 and section 20, which is probably where the most issue would come up with what you're asking, Tanvi, is if you think about it, the actus reus is the same, so you would still get your credit for talking about wounding or really serious harm. You would just probably lose a couple of marks for getting the wrong mens rea. If it's absolutely different, then yeah, you wouldn't get the marks for it, I'm afraid. If it is that GBH problem, you would get your actus reus marks because you are applying those as long as you know the law and you present your cases and you explain them. It would be your mens rea that you would lose marks on, but that's only like maybe 1 or 2 marks. Nothing too bad. Could we mention some evaluation points briefly in your application question? No, please don't do that. Application questions, you will get no marks whatsoever for evaluation. So if you do that, you will just be wasting time, and that time could then be spent on your evaluation question. The evaluation needs to stay in your 12 markers on section B, or your 12 markers, should I say, the one you choose, and then you keep it in on the 20 marker. Do not bring any evaluation for the OCR paper onto your 20 markers. There's no credit whatsoever for that. Brilliant. Will we lose marks if we don't put any case facts and talk about the point of law? Don't put any case facts. Case facts are not really that relevant. It is the point of law that your examiner will be looking for. They want you to know that you know the law of the case. Your teachers will teach you the facts because, one, it helps you remember the case, because let's face it, criminal law is dead interesting and these are all crazy cases. And number 2, you could get something in this scenario that's very similar to a case, and the examiner will be wanting you to talk about it in that way, applying the law from the case, but no facts. I wouldn't bother. You'd just be wasting time. Stick to the points of law and then give some really detailed application in that point as well. Fabulous. Is question 7 and 10 an essay question? Yes, it is. So that is your evaluation question. So you would talk about your AO1. There's 8 marks for AO1. Remember, AO1 is the knowledge. So let's say if intoxication comes up, write what you know about intoxication first. So talk about it. Being what voluntary intoxication is, tell me what a basic and specific intent crime is, then tell me the rules. Go through the actual rules first, like you would do for a scenario, and then boss your evaluation. So put those extra 12 marks in for evaluation, and then pop your concluded. For the 8 markers, do we need to be do they ask a very specific question, or is the questions broad? No, the 8 markers tend to be specific. So it will be things like, what's the qualification and selection of magistrates? So they're just looking for qualification and selection marks. What are the aims of sentencing? So they're just looking for aims of sentencing. Describe mediation. So they're going to be very specific, yeah. And they're going to be looking for 8 marks of pure knowledge, simply about that topic that's in there. It will not be a broad question. It will be very specific on that one. Fabulous. If we miss out all questions in section A because you've run out of time but done section B, is there still a chance of getting a good grade? Yeah, of course there is. Loads of people miss out section A. I wouldn't recommend it. I would really think about the time that you are spending. I mean, it's nothing to cry over or get upset over if you do miss out section A, but I'd try not to. You want to think about those percentages we put on earlier. So 25% of your paper is section A. So that really means that you should be spending 25% of your time. So 30 minutes on section A. And then you want to be spending 30 minutes each on each of the 20 markers in section B. So if you think about those timings, I always advise my students, when the clock starts, before they even open their paper, work out your 30-minute timings and try and stick to those as much as possible. It is better to stop when your 30 minutes is finished and go on to the next question and your next 30 minutes than to keep going and miss out more. You'll get more marks if you answer across the paper. So keep an eye on the time would be a massive top tip. Make a note of it if you need to make a note of it. And always leave space, because you never know, one question could take you quicker and then you could go back and answer it afterwards. But I would try and make sure that you answer all the elements that you are supposed to. So your section A and your section B too. Brilliant. If we only include 3 cases, does that limit what level you get into on that question? That's a hard question, I'm afraid. I advise my students to put 4 or 5 cases in for a TOC mark answer. It is hard to say what 3 cases would give you on that one, but I would definitely be aiming for at least 3, 4, 5 cases per question. But also remember, it's not just your cases, it is your statute as well. Statute classes as legal authority. So make sure that you use statute. So if you're talking about the Theft Act, talking about Section 3 and appropriation, and specifically saying Section 3 appropriation is going to give you just as much credit as using the case of Morris as well. So don't forget those statute also class as legal authority. We've got another question. What is the best way to score high marks for application scenarios without simply repeating words or lines from a scenario? Ooh, X, that's a fantastic question. So my top tips would be, if you think about the legal principles of your cases, that's your application starting point. So, or even what the statute says. So if we go back to just looking at Section 3 of the Theft Act there, assuming the rights of the owner is appropriation, use that as your starting point. The defendant has assumed the rights of the owner, that's your law, because, and then explain, referring to the scenario. So I always get my students to practice using those legal principles or using those points of law from statute as like the starter sentences for their application. Add that magical word of because. If any of you have been to our lovely grade boosters, you'll have heard me talking about that lovely magical word of because. We add that onto the end of the point of law, and then we can use it as a brilliant way to use those scenario facts to explain how that law has been satisfied. A good way of getting top marks too would also be, after you've used the magical because, is can you argue at the opposite side? So can you argue like the defence and prosecution? Is there a way that could suggest that that might not be the case? And think about it. I would say as well, there's 12 marks available for application. So if there's 12 marks, you want to be saying 12 things, if at least, if not a few more. And don't forget, you need to have that conclusion, so the guilty or not guilty on the end. Brilliant. A case needed in the legal system areas. If there is a case in the legal system area, I would put it. So arbitration, you've got your Scott and Avery. I suppose that's like a case in its Scott and Avery clause. There is some cases in juries, the Juries Act, that you could refer to that statute. There is less cases in the legal system, but if you have one, put it in. It's more about explaining the law or the legal system on that side, Harris. But yeah, if there's something where you've got a case that's in there, I would definitely put it in, definitely. Do all the questions need conclusions in their answers? Tanya, very good question. So for Section A and your 8 marker, no, you don't need a conclusion. For your 12 marker, no, you don't need a conclusion. But for your Section B, so for your 2 scenario questions, your 2 20 markers, you do need a conclusion. That conclusion is guilty or not guilty for the people involved. So if you've got 3 people involved in a scenario or 3 robberies, then you need to conclude on each of those. They are guilty of this one, they are not guilty of this one, and they're guilty. That would be the same for both of your scenarios. Make sure you've got a guilty or not guilty. And then for your evaluation question, the essay, yeah, a conclusion. You need to answer the question, sum up your main points that you've said, and actually answer that question. So if it's saying, is the offences against a person in need of reform? Answer that. Give a clear answer. Are they in need of reform? Don't sit on the fence. Give a definite answer to that one. Brilliant. If we come to the wrong conclusion but we explain it, do we lose marks? I'm not necessarily giving an answer on that one. Normally, it is very clear if it's guilty or not guilty. So you would need to work it through on that one. But if you are unsure, I wouldn't stress too much over it. It's not a point thing, but I would try and work through the law. Remember, if one of your parts of the test fails, that means that they're going to be not guilty. If the tests do satisfy, then they are going to be guilty on that one. Brilliant. Will we lose marks if we get word for word the 2-part test or definitions? No, not. It needs to be as close as possible that you can possibly get it. But if you just muddle a couple of words up, no, that's not going to cost you greatly. As long as we can see that's there. But you can't be rewriting these definitions. These have come from judges and Parliament. But you can. There is a bit of leniency there on that factor. But yeah, I try and get it as close to word as you can do. A whiteboard's fantastic. If you've got a mini whiteboard, write it out, rub it out until those definitions are in your head. Brilliant. The difference in custom, common law, and statute law. So, common law is your judge made law. So, it's all of your lovely cases that all your amazing teachers will have been teaching you. And then your statute is the Acts of Parliament. So, there we go. If test fails, do we still continue applying to the scenario? Another excellent question. Yes, you do. If you are midway through, let's say you are, I don't know, we'll go back to theft again, and you get to belonging to another and it fails. I don't know why it would fail belonging to another, but let's say it does. Yes, you carry on. You complete every single stage of that test, and then you say they're not guilty because of the stage they failed on. You will lose marks if you stop at the point where it fails. So carry on your full application. Even if one element fails, go through everything else, and then tell it in the conclusion that's why they're not guilty, or that's why the defence can't be claimed. So there you go, Tanvir.
Brilliant stuff. We've come to the end of our 30 minutes or so. Thank you so much for those questions coming in. It was wonderful to see them. Some really good questions there as well, I thought, Laura.
Yes, fantastic questions. All really good, more technical questions. It's fabulous. Well done.
And of course, massive thank you to Laura for having a go at answering some of those there. One or two questions asking about predictions for what might come up. But as always in these live streams, we can't make those predictions, can we? It doesn't matter whether it's Laura or any other subject. So apologies if you were hoping that we might tell you what was on the paper. We won't be doing that. Hopefully you found tonight useful. If you have done so, please do give us a thumbs up in YouTube. That helps us get our message out there. We'll be back next Thursday when we start to do a few live streams in preparation for paper 2 and then moving on to paper 3 later on to that. So we won't see you again before the paper 1 exam. So on behalf of Laura, myself and everybody, of course, at TutorTU, the very best of luck with that and any other exams that you might be taking over the next few days. Thank you, everybody. And goodbye.
Bye. Thank you.